Mike owns and operates a company called IP Consulting Group, where he provides intellectual property consultation to inventors and businesses to help them develop their intellectual property portfolios. Mr. Razavi served with the US Patent and Trademark Office for over 30 years, where he was on the leading edge of innovation and worked to improve the functioning of the office, and also to strengthen our partnerships with business, with education, and with other patent agencies across the ocean internationally. So he has a ton of experience in this area. For about 20 years, over 20 years, he served as a spokesperson for the Patent and Trademark Office, where he presented technical and non-technical information on intellectual property and other related topics to small groups, to large groups, to national conferences, and where he also served as a senior executive advisor to the Office of Undersecretary and of the U.S. Patent and Trademark Office.
As Rebecca mentioned, I've worked both in private industry and government for many, many years. I left government about 3 years ago. I was the senior advisor to the Undersecretary of Commerce and the Director of United States Patent and Trademark Office. I'm here basically talk about intellectual property, which really I say is existed in the United States for somewhat of 230 years. And it's really going to be hard, in 1 hour to go over everything. So I generally start with where are we? I just give you a broad overview of 230 years ago to today. I've come up with about 3 pages of questions. We're not going to answer all of those. Feel free if you want to contact me after the program sometime in the future. I would love to have a discussion with you on those. Recently, I was on one of the international shows talking about the intellectual property and the economy between United States and China. As you know, this has been one of the big topics for the past many, many years. And then I'm going to walk through, and my apology for the people know more about intellectual property, kind of talk a little bit about basics, what IP is, what it means really, intellectual property. And at the end, if you have questions, hopefully you do, I'll be more than happy to answer all of those. I put this up, as I mentioned, intellectual property is part of the Constitution of the United States, was put into the law roughly 230 years ago. Initially was copyright and patents, and then it switched. And also it was added, trademarks were added later. This just shows you, I was in the office, and actually I worked on on the committee. We put together the 10 million patent. We had a huge celebration. We had President from the White House signing a 10 million patent. It was a big ceremony. We started, patent number 1 was signed by George Washington. So we thought it was symbolic. We had patent number 10 million signed by the president. But the reason I'm putting this up, not too long ago, patent number 11 million were in the history of the United States were issued. And if you look at in 230 years, and I was just telling Rebecca a little earlier, I said I worked for the patent office a little over 30 years. I was there when patent number 5 million was signed. And just look at in roughly 200 years, we went from patent number 1 to 5 million. and just about 30 years or closer to, just about 30 years, we went from patent number 5 million to 11 million. So this is just showing how fast we're innovating, how fast we're inventing, not only in the United States, but really in the world. So with that, I'm gonna start the questions I mentioned. Here, some of the questions, again, to think about, what does really intellectual property means in 21st century? Right before you guys joined, I was talking to John, and we were talking about copyrights, what copyright really meant maybe 20, 30 years ago, and really since the inception of internet, since everybody can put their any type of copyright, any type of material, or songs, or books, or the recipes, for example, on the internet. What does copyright mean? How could they protect it? What countries lead the world in intellectual property? As I mentioned to you, there is a big issue going on between, and it has been going on between China, United States, and a number of other countries, obviously. How does intellectual property really relate to the strength of the country's economy? We've done many studies, and really the GDP and the number of patents and patent applications, it's hand to hand in most countries. The differences between innovation and invention. What really is invention? Is the invention really when you come up with a gadget, with a design, with a new improvement of something? And innovation, I call it pathway, how you really bring that into market, how you advertise it, and how you are able to get it into people's hand, companies, and others. The next thing is the different type of intellectual property, which we're going to talk about. What can and cannot be protected, what apply for the IP, why apply for IP, is there any downside, the infringements process in United States, and how can you enforce your patent? And there are lots of different arguments to that. As far as the enforcement goes, really since I say when Reagan became the president of the United States, we have changed. You can take your intellectual property to all different steps, different type of courts, and be able to defend your IP. Maybe mention a little bit about costs of copyright and patent and trademarks, how long it takes to receive them, and how long do they last? Is my IP protected in the world? The role of how does USPTO review patent applications or trademarks? How can you get help, and do you need agent or attorneys? So this slide here, I put that it just answers some of those questions. The patent applications last from the time you file, it would last 20 years. And we're going to talk about it shortly, but it would just show you how long the utility application, what it is, and how long is protected for once you apply. Design, which is 15 years. Trade secrets, which I'm not a fan of, is really until it's revealed one form or the other, and we're going to talk about that shortly. Copyrights, as I was just mentioning earlier, is the life of the author plus 70 years. So really you can pass it on to the next generations. And trademarks last forever, really. As long as people pay the fees, copyrights can be alive. So trademark is a common law, basically protected, is from the use. You can have your goods, or it can be a service. Generally, if it's good, you put TM, or if it's service, we put SM. And you've seen in front of names, people put TM or SM. It doesn't mean you can start your company with having your name or your logo for your company. However, until you file at US Patent and Trademark Office and it does get registered federally, you cannot defend it in the court in case somebody tried to copy your name or logo. And once that happens, you see R in front of the name, and that means it's been registered. Again, trademarks are a common law. Lots of people usually make a mistake. They say, oh, already registered my trademark. More likely, they've registered it at the state level. Most people have registered their names at the state, but at the federal level, there are really not that many. I believe we have 6 or 7 million trademarks. I have not looked into see how many, from the time we started registering trademarks, how many trademarks we have. But I believe it's 6 or 7 million. So copyrights, again, is a common law. Is original work of authors. Is literary, dramatic, as you see, music, work of arts. They're all, once you put in the paper or once you start the music and the notes, they're all can be copyrighted. Books. One of the questions I usually ask, from audience, I ask people to raise their hands, see how many people own copyrights, and I get very few hands up until I ask people if they've written any poetry or any papers, any research papers, any letters, and just about everybody has done those. And then I let them know that they all own a copyright. It has not been registered, but they do own a copyright. Once you're ready to register your copyrights, Library of Congress administers that, and you go online. It's very easy to apply, or you go to a council and they would file it for you. As I mentioned to you, once you receive your copyright, it lasts the life of author plus 70 years. A few years back, maybe 10, 15 years ago, there was a video that got to be very popular, and lots of people were buying those. It was a game, and they were having very, very success in the sale. One day, one of the people was watching, noticed one of the characters has a specific tattoo on their arm. And later he found out it's the tattoo parlor, one of the people close to his home. He's been putting that on people's arms. And he went to him and mentioned about the video. And make the story short, since he put that together and he applied, he got the copyright, he owned the copyright for that specific tattoo. So his attorneys contacted the company that was selling the video, and they were able to come up with a great settlement. So what I mean, basically, if you do have some work, you want to make sure you register it and you get your copyright. You never know when in some ways, you have to protect it and defend it. Next is trade secrets. And the question here is, which company kept their secret so, I said secret, so by mistake, they lost it. for almost 40 years. And you can see really the answer is there right in front of you. It was McDonald's. Their ketchup recipe was lost for 40 years. Anyway, they finally got it. But trade secrets, as you see the name, it basically lots of people want to protect their formula or their customer list, their recipe, their search algorithm, and so on and so forth. So they're afraid to put it in a form so they can apply, and they want to keep it as a trade secret. And they generally share it with their partner in the business, and they hide it somewhere. I was recently watching a show. These two women, they were having a very successful small restaurant, and it was the same thing. They had this special recipe that they've gotten it from their grandparents, and they never revealed it. And one of the question was, what happened if something happened to you guys? You can definitely, if you register this, you can pass it on to your children. So with the trade secrets, again, is a common law. Okay. It's a common law, which is very easy to be lost. If somebody steal that, for example, if you keep it at home, you forget, you write the recipe somewhere and you forget to lock your safe, and somebody comes, takes it, it's gone. If somebody does a reverse engineering, or by any chance they come up with the same recipe, for example, or the formula, you're out of luck. And we've had people coming to our office, and the same thing, they were making some specific cookie, they were very successful, and all of a sudden others start making the exact same thing, and they would come to us as, we're very sure they're copying our recipe. And our question is, did you get any IP? And they said, no, I just kept it as a trade secret. And I personally, as I mentioned in the beginning, I'm not the fan of trade secrets. At some states now, you can get limited. You have to litigate it, and maybe you get something out of it, but it's going to be very difficult. Basically, what the patent is in the United States is the right to exclude others from making, using, selling, or offering for sale, or importing what you're claiming as your invention in your patent. It's a limited term. As we mentioned, it used to be 17 years from the time you receive your utility patent. Many years ago, about 15-20 years ago, we changed that to 20 years from date of filing, unless it's a design patent, which you have 15 years protection from the time you receive your patent. Is territorial. Again, I have clients calling and they say, I just found out my invention is being produced in England or some other country, and what can I do? And my first question is, did you apply in those countries, or we have another way called PCT, Patent Cooperation Treaty. Did you file your agent or your attorney, did they file PCT in those countries? And they say, no, I only have a patent in US. And my answer is, well, you're out of luck. Unless they bring your invention from that country to US and they try to sell it or basically publicize it, then you can stop them. But other than that, they can do it in any other countries. And that's why when we apply for a patent in the United States, we have X number of months before you have no more rights. You know, we have X number of months to file in other countries. And again, depends on the country. And again, depends on the invention. One of my question is, what is your invention? You know, is this something that You have to think about, are you going to make it in United States or you're going to make it in other countries? And then second question is, once it's made, are you going to try to license it or you're going to produce it yourself? And if you're going to produce it, is your plan to sell it in United States or other countries? Because also that's how we make a decision whether you need patents in other countries, for either producing it or selling it in the future. So this slide basically talk about what can you get a patent for. If you have any type of process, you can apply for a patent for a specific process of coming up with a specific drink, for example. If you have a manufacturing process, if you come up with a new way of putting together, making a battery, for example, method of making something, you can apply for that. Any type of a machine, any type of device that you come up with. Most of these inventions, you can always improve. You can look at the whole space. These days, as you hear, robotics is huge. Artificial intelligence is huge. And how do you see the state of technology, and you can build on that, and that's called an improvement. So you can improve that technology, and you can apply for a patent. So the criteria to get a patent, your invention has to be, in order to apply for a patent, has to be something novel, has to be something new, has to be useful. You have to show utility, you have to show that it works. And it has to be written in a clear, descriptive language. And it has to be unobvious over what has been done before. And that's an argument and depends on basically your counsel who is helping you, and what technology you're in. So what's obvious and what's not, it's can go a long way. For example, if you come up with a new, let's say, cup that the handle, instead of being rectangular, is round, is that obvious over what was made before, for example? Versus if you come up with a type of a tire that in case you get a nail in it, it loses the air, but it's able to detect it and inflate itself. Is that something obvious over what was done before? So, but that's the criteria of others. I mentioned to you, we have 11 million patents. I was in the US, I was working with Patent and Trademark Office when we issued the patent number 10 million. And this was Joseph Marone is a laser, which is a combination of laser and laser technology, which is being used in the medical field, really is in space, in medical, and just about any technology, this specific technology was being used. I know I went through all of these fast. This is just I have a basic fees. This is the fees that United States Patent and Trademark charges for filing a patent application. Generally depends on what we call a micro entity, small entity, or large entity. You could be paying from 400 something to 1,200, 1,600, depends on what you're applying for. And that's just not the counsel, that's just the fee at the US Patent and Trademark Office. Once you receive whether your patent or trademarks, what is called is a maintenance fee, which every so many years you have to pay to keep your patent or trademark alive. I have some of the resources at the USPTO that they can basically help you. I recommend, and not because I have an office now, I recommend get a counsel because the process is very complicated. So you truly, can get help to apply for your intellectual property. We can go through questions, and I think that's one way everybody would benefit generally. I've even stopped giving this type of presentations because I think everybody benefits more from, Q&A. So.
Great. Well, we have some questions that have come through, and I'm happy to share those with you, some really interesting ones. If anyone else has any questions, you feel free to put them in the chat. There are about 6 that came up so far, so we may have some time for a few extras. One of the questions was about the symbol with the R or the TM, I guess, for trademark. When would you use that?
Well,
where and when would you use that symbol?
Yeah, if you come up with let's say you start your company. As a matter of fact, I have a company just opened right next door to me, and it's a beauty salon, and they have their name, and they were asking me. I asked them if they've applied for trademark, and they said no. So I said they can put a TM next to their name. Now, they're selling some goods, but also they're giving a service. So if you're selling just goods, your name represent just the goods that you're selling, you put a TM. If you are giving a service, a beauty salon, if you're working on hair or face, or so they're giving a specific service, they put SM. And then what you do is, I highly recommend also come up with a logo, because that's how most people are being recognized these days, as you all know. So then you go ahead, apply for your trademarks. Once it's been registered, you've been granted, because Trademark Office, they go do a search, they have a specific criteria. Once that's done, it gets changed to an R. And then you just put the R in front of your name. So anybody sees, initially, they see you're thinking of trademark, but it hasn't been registered. And once it's registered, you see the R.
This should be an easy song. Do you know, an easy song, do you know if Happy Birthday Song has been copyrighted?
No.
No, it has not? Or
well,
no,
if you ask me top of my head, I say I'm pretty sure. And not only in US, probably other countries with different languages, as you all know. But also, you can also get a copyright for different smells, by the way. Have you seen, perfume with different smells? So that's been copyrighted too. So the best is really to again, if you can search yourself, but if you go to a council, they do a search for you, and once it goes to either the Copyright Office, or if you have a trademark, goes to Trademark Office, they also do a search.
So the follow-up question, I think, might be, where do you find out if there is a copyright or a trademark or a patent on your what you think is your intellectual property?
Well, I would not just, lots of people come to us and they say, oh, I've done my search. I said, how did you do your search? Oh, I've gone on internet. Believe me, that's just a small piece of it. One good place, if you don't want to go pay for it, one good place is go to the United States Patent and Trademark Office. They have a wonderful library. And when they were open, I'm not so sure they're still open. I know they've been closed for, as you all know, about a good year and a half now. They can walk you through and they help you do a search on your patents or trademark or copyrights. Generally, my firm, if you come, we do the search as part of the service. Because I don't believe, you should waste your money and your time if we have an identical, very close, either is a patent or trademark or copyright. So we do a search. It would cost you a little bit if we move forward. And lots of time when we do a search, we find out if something is close, we can give you an idea. And as an inventor, you're able to modify your device, your little system, even really your logo or trademarks, and then you change it a little bit, then we go ahead and apply.
Can you patent an idea?
Well, who was it? Somebody said the ideas worth, I don't know, 100 a dime, and who is able to get it and actually put it together is worth. When we put together in what we call an application, it has to be, as I mentioned to you, it has to be, you can have an idea that could be for a process, a machine, some kind of a device. It could be for a method of doing something, but really you have to be able to put it together. We have to show how it's put together, has to have utility, has to work. It has to be unobvious what was done before, and has to be new. So there are companies that actually, if you go, let's say, you come up with a new way that if somebody's ready to fall is detected, and they can call the ambulance, for example, right? So you come up with a new watch that can detect that, the pulse of the person, for example. There are companies that they have engineers, physicists, scientists that actually help you to put that system together. And once that together, called licensing, they take a big portion out of it, but they're willing to work with you, do that. But just an idea, if you go, no, you cannot. It's a long process. Once you apply for a patent, initially it has to go through pre-exam, what they call, then it goes, United States Patent and Trademark Office has close to 13,000 employees, 10,000 scientists and engineers and attorneys. They do a search, they analyze your invention, they check it against others, and the patent laws, they're about two books that they're each size of about, I say, 7-8 inches thick, each one. So based on those patent laws, they make an evaluation, and it's a long process, go back and forth until the decision has been made.
Okay, so there's a complex question here from one of the faculty at Montgomery College, Lori Kelman. And I'm going to do my best, but Lori, feel free to jump in if I miss something. Since it's in multiple parts, I'll ask piece by piece. The first is about what is your opinion about the shift from, is it first to file that's now first to invent, or is it might be the other way around?
No, it's first to invent to first to file.
So it's now first to file, meaning that
Yeah.
your protection starts only after you filed. Do you have a perspective on that change?
Well, the change happened during the Obama's administration. I was working actually with the director of USPTO called David Kappas. He was the director at the time. And I said, somewhat involved. It was called American Invent Act. A number of changes happened, and one of them was we went from, most of the world, their system was first to file rather than first to invent. And first to invent was, if you invented something and then, let's say, patent office found another invention that was done 6 months before you filed or a year before. If you were able to show your research papers, you were able to demonstrate that indeed you were working on that 4 years ago, and it was really, it was at the point of the invention 2 years prior, they would take that into account. And that was first to invent. Versus first to file, really, that went away. So I tell people, and not everybody agrees with me, I said, well, as soon as you come with an invention, you really want to go ahead and file. And we have two different kind of filing. One is called provisional, one is non-provisional. Provisional application is very inexpensive. It doesn't cost you much. Even the council would charge you usually less. But we put it together and we go file. We get a priority date. We get a date in, and we have 1 year to complete that application. And then once that year is up, it dies really. So within that 1 year, usually we file the utility or what's called non-provisional application. My opinion, just to give, I wish it was otherwise, because if somebody else, I've had clients, they say, oh, I can swear my invention. I was talking to somebody and they heard about my idea and my invention. They ran and they filed it before I was able to do it. What can I do? I said, really, with the short of litigating and taking them to court, and even that is going to be very hard because we're first to invent, first to file. It's really difficult to do anything. So I wish it was otherwise. Let's put it that way. So that's the short answer or long answer to the question. So
exactly, it is what it is, but
yeah,
too bad. That's too bad. So we have another patent question, and then actually, and there's also a copyright question. So the patent question has to do with if you have a method that you wanted to get protected. And the example is on teaching how to hit a baseball, for example. If that's a new method to do that, where would one start?
If you're just starting, if your passion is to come up with a new way of hit a baseball, you said, to look at the history, to look at really all the patents and all the publications and everything that's out there, just to look at the state of technology, where it is. I generally teach my clients, let's find out where the hole in the technology is. What are the problems? And you as an innovator can really think about solutions. And then you can come up with that, and then we can work together, see how you're able to put it together in a reasonable way in a patent application. So if you already come up with it, have a method of doing it, then I say you can do it yourself. You can put together and file it yourself. I don't recommend, especially for patents, even trademarks, really. Then, if you want to call me, I can just give you some advice on the side, but get a counsel. I think in the long run, you're going to save time, and you're going to save lots of money.
Do you recommend that people use, I know that like Google has a relationship with the patent office, and there you can do a patent search. Is it patent.google, or, it's very easy to find that website. Is that a good place to start if you just want to get an idea?
Yes, you can. As I said, if patent office was open, you can go to US Patent Office in Alexandria here. There are a number of libraries around the country that are affiliated. And the reason I say patent office, because they have two systems that examiners use called East and West, and you would have access to those specific search engines, and it's totally free. You can do a Google search. Again, if you come to us or you go to any counsel for a fee, because when it's search, it's not only US patent, it's all foreign patents and just about any publications in the world. So it's really important to do a comprehensive search and put together and put everything in front of you, and then make a decision, whether it's a yay or nay, or maybe you should still work on your invention a little more before you get it to the point to file.
Fantastic. That's a great answer. There are two copyright questions, so I'll ask those kind of in combination. The first one is, if you're automatically have your work copyrighted just because you've produced it, when would you want to apply for a formal copyright? It's kind of the difference between those.
Really, some counsel says, well, you're not pressed under, any timeline. I disagree, because again, in today's world that everything is on the internet and overnight, you can send it all over the country or anywhere else. I say, once you have it, make a decision. To get a copyright is really not expensive. People can take a segment of your book or your poetry or whatever you wrote and put it under their name and change it. So again, go ahead, apply. If you come to us, the fees are very little, and we put it together. There are questions. I just did a copyright for somebody, and within their I said journals, they had dates of other that they were conceiving this whole book or / journal, but they had other dates, and we had to make sure we knew when it started and how it was improved. So there's some process that has to be complied with when we're ready to file for copyright.
The other question that had come up about copyright, I'm just going to read it so I get it right. It says, are there rules on certain things you cannot copyright? For example, it seems like everyday items are not copyrighted. Actually, I think this might be a patent question, like TVs, pillows, beds. Those would be patented, I believe. If someone was to copyright those, would it mean only they can produce them right now? And I think we're talking patents, right? About
yeah, you can. Let's say you come up with a new recipe, right? Let's say you come up with a new way of putting together a pillow that is soft and everybody would love to use. Right. A new pillow for your dog or pets that love to use, for example. If you put it together in a sense that explains, you can file definitely for a patent, but doesn't stop you also filing for copyright. More IP to me is better, especially if somebody's going to infringe it. If it gets to a level either negotiating with the other party or going to court, is better to have more than less. I just have one of my clients, one of his inventions, he has a number of inventions. He's selling them Walmart and some of the other big department stores. And we were able to put something together, and he went to Walmart. The people were copying his, and Walmart just pulled them off the shelf. So, it's really important to have the right thing. So,
right. So, okay. So there is another copyright question, and then there's another patent question, and then there's one more question. And then I think,
let me yes. Before, and I'll stay on until we answer all the questions if people want to stay. I also want to just bring up something. This is something I've been facing with some clients, by the way. If you work for a company or school, any kind of school, from all the way elementary school, and I've had clients working with elementary school all the way to colleges and universities. If you do a work, whether it's at the lab or you're a inventor coming up with something, who owns your invention? Once you conceive something, you're always the inventor, but who truly owns it and can stop you from selling or producing or licensing it? If you work for and I've had these questions, and I said I've had clients, whether working for government, working for a private industry, or working for any level of schools. Something just think about, and if you have those situations, I just want to make sure people are careful what they sign when they start working at school, or if they're affiliated with school or some other institution somehow. So but
I'm
anyway,
so glad.
I just want to throw that out.
Yeah, I'm so glad that you brought that up. I don't know if there are any other Big Bang Theory enthusiasts, but there is an episode there where they run into that exact problem, where they've invented something, but they work for the university, and it turns out it belongs to the university. So it is.
And I do have a client right now. We're going through that specific topic, what you just mentioned. Yeah.
Right. Very interesting. Cool. Okay. All right. So the other copyright question is about things that are put up on YouTube specifically. I heard that anyone making content on YouTube that they own is inherently, anyone making content on YouTube that they own is inherently copyrighted to them. Is there an automatic copyright that protects their works, and how would that protect, how would this protect somebody?
Well, by just uh, basically putting a C at whatever you put together, whether it's a music, or is it, it's a poem or whatever, um, and your name and generally a date, you show that you just put that together. However, if I decide I see that on YouTube and I see really that's popular, you're getting, 1,000 hits a day, I could copy that and try to put it on some other platform. So to stop that, you really, in order to be able to litigate and the court hear you, you have to have it copyrighted. So in that case, that's why I suggest before you do that, if it's something, again, we live in an era of open space. Oh, I want to share everything. What people don't understand with the copyright, not so much, but what people don't understand, especially with patents, if somebody else goes get the patent, even though you want to just share your invention, whatever it is, if they get that patent, they can come stop you from doing what you're doing with your invention, because it's first to file and who owns that invention. With copyright, not as much, but they can produce that and start selling it. And by the time you find out, so again, my suggestion is go get your copyright. It's not that expensive. Getting an intellectual property is almost like one of my analogy is, what happens if you own a, let's say, a motorcycle, and one day somebody sits on it and they say, I want to ride this, and you have to call the police. How do you prove you own that motorcycle? Is by that title that was given to you at the time you bought that motorcycle. Or if you buy a property, you have a house and a rental house, somebody else moves there. How do you prove that it's yours? And again, it's the title that is given to you. So intellectual property really is nothing different than that. It's by the time, when you get your patent, your trademarks, your copyright, it just shows who owns that. To me also, even if you don't license it or sell it or don't get it to the next level, is a pride. It's something, an accomplishment, not only during your life, but also next generation, for your children and grandchildren. It shows you were able to intellectually put something together. It's a pride. It's a way of motivating ourselves while we're here on this planet, which is so beautiful, and we have so much opportunity. And I wanted to also add something else, by the way. I used to go, as Rebecca mentioned, I used to go not only inside the country, outside the country, give presentation and talk to different inventor groups, from physicians to doctors to universities. But lately, for past 10 years or so, our high school students and middle school students are applying for patents and trademarks and copyrights. So if this is to the audience, the students sitting there, if you haven't thought about getting your intellectual property, you're falling behind. Start thinking about it. So and if you need help, as I said, I'd be more than happy to help you, with the conversation and help you to get to that level.
I thank you so much. That may be a great place for us to end.
Thank you all putting up with me for the last hour and listening. And I wish you all luck and success.